We're talking about when life begins and when it's acceptable to end it. Does the sponsor have a position on when human life begins?
It's irrelevant to the bill what my personal beliefs are. This is a matter of medical judgment. We, in many instances, defer to the medical professions for these determinations. So those are folks who have been trained and educated in the sciences, etc., and who deal with this actually every day. And so we focus this is why it is in the public health law that medical professionals acting within the licensed and legal scope of practice make these determinations, not individuals distant from them sitting here in this chamber.
So the medical experts who informed your drafting of this bill, when did they say human life begins?
That was not the question that we asked. We asked...
Clearly.
I'm sorry?
Go ahead. I said clearly it wasn't.
You have another question?
When is an unborn child entitled to legal protections?
Well, it is not constitutionally, since that was raised by another member, the Justice Blackmun said that all of our constitutional law is based on the presumption of laws affecting individuals postnatally. So that is, I believe that all of our laws are based on people who are born and alive.
So how about a child who is partially extracted? His or her head makes it out into the atmosphere here. Is that child or fetus entitled to any legal protections?
Well, I'm not sure exactly what you're referring to, but there was a particular procedure that has been banned and was banned in over 10 years ago, and while medical professionals indicated that they thought that that was a political argument and not a medical one, and in some instances that procedure was probably the safest to use in a termination for the woman. Nonetheless, the federal ban on what was called partial birth abortion still stands today, and nothing here in this bill changes that.
I know you cited some provisions of this bill that are in place because the old provisions were ruled unconstitutional, but I haven't heard a case citation or whether the court that gave that decision was a court that has binding precedence over our system here in New York. So can you give us the case?
Well, I think we all took an oath to uphold the U.S. Constitution, so I think it does apply to New York State.
Sure, but one of our colleagues asked if it was accurate to say that under this legislation, abortions after 12 weeks of pregnancy would no longer require a hospital setting. And you said that's because to do otherwise was unconstitutional. I'm asking you, who said it was unconstitutional? What court? Is it a court that has binding precedence value over this
The
state?
Supreme Court of the United States. Was that Heller's Queen?
That was the City of Akron versus Akron Center for Reproductive.
City of Akron versus the Akron Health Center. That it places an undue burden on women seeking services, and did not have any medical necessity.
Thank you. Shifting to the penal law aspect of this, I'm going to read just a few sentences from an article from just last month, right down the road in Saratoga County. A North Lumberland man was arrested Sunday for allegedly punching a pregnant woman's abdomen in an effort to kill her unborn child, police said Monday. Stephen J. Miller, 39, of Colebrook Road, was charged with second-degree abortion, a felony, and misdemeanor reckless endangerment after he repeatedly punched the abdomen of a woman he knows who is 26 weeks pregnant, according to the Saratoga County Sheriff's Office. The sheriff said Miller was trying to cause a miscarriage. So my question is this. Under the current state of the law, the authorities in Saratoga County last month were able to charge this perpetrator, the perpetrator of this heinous crime, with a felony, second-degree abortion, which is a felony. If your law was in place when this happened, would that felony be able to be charged?
Well, certainly assault in either the second degree or which is
No, I'm talking about the second-degree abortion felony. He was charged with two crimes, a misdemeanor and a felony. The only felony was the second-degree abortion.
Well, that is actually, in my humble opinion, rather poor on the part of the prosecutor. The prosecutor could have charged
You have an opinion on the prosecutor, but not on when life begins? Is that your position?
an assault in the second degree, and that would have been a more appropriate charge. It's a violent felony and would have actually been subject to a greater jail time than what was charged by the prosecutor. I'm not going to opine on whether or not the prosecutor was trying to make a point, but there is a violent felony that could have been charged and perhaps should have been charged instead of that crime.
You know, I'm going to give the law enforcement agencies and the prosecutors the benefit of that doubt. They know the facts and what they're able to prove. They believe they can prove two crimes. One's a misdemeanor, one's a felony. Under your bill, they could not charge that felony, correct? That specific felony.
They could not charge the felony that they chose to, but they could have and should have chosen a violent felony assault.
Thank you. This bill that we're debating today, it protects abortion rights throughout the pregnancy if the abortion is done to protect the health of the mother. Is that correct?
Yes.
And how do we define in this legislation the health of the mother?
We don't. You don't go to the legislature when you're sick, you go to a doctor. So we leave that to a doctor.
So is it accurate to say even the most minor health conditions would allow for a 9-month abortion?
Mr. Lalor, I'm going to try to be respectful here, but let me just say that the constant attempt to suggest that women choose abortion late in pregnancy on a whim because they have a headache or a hangnail is insulting to the moral fiber of women in this state.
I didn't suggest that at all. I just asked a question. Let me move on.
Thank you. We don't need applause at this point in time. Thank you.
Presently, public health law, section 4164, it contains a provision relating to the rights of infants who are born alive. Specifically, it says a viable infant born alive following an abortion performed after 20 weeks gestation, quote, shall be accorded immediate legal protection under the laws of New York. Your bill repeals this. Why?
That section of law has been held unconstitutional because of the requirement for additional medical personnel, which is an undue burden on providing the services needed.
So is it accurate to say right now, on the books, we have a law that says a aborted fetus that survives the abortion is entitled to nothing? No protections?
Well, the line is, if you are born alive, you are alive. If you are not born alive, you are not born alive.
In a situation where that happens, when a child is born alive, under this bill, what would happen? There's no command in the law to try to give aid to that child who's struggling for breath, whose heart is beating, who's out here on the earth?
That is totally a matter of medical judgment. If that fetus is capable of surviving, I can assure you that medical personnel would do everything in their power to try to save that fetus. But the question remains whether or not the fetus can survive outside of the mother's womb. And if a fetus is somehow delivered and is alive, then it becomes a person under New York state law and is granted all of the rights of a person if it is alive.
But we're not going to mandate that the doctor actually treat it. We're going to leave it up to the doctor. We're not going to put on in our statutes the call to actually treat this child.
Well,
And if so, why not?
the purpose of the bill is to ensure that we provide medical judgment and respect the medical judgment of those involved. And so
Mr. Rea, why do you rise?
Will Ms. Glick just yield for
I
one
don't
quick...
have my, it's not on
one
my
click-
time, Mr.
One quick clarification based
Mr.
on what they're discussing.
I'll yield.
Mr. Lawler has the floor. You have to ask him to.
Mr. Lawler, will you yield and will Ms. Glick yield? For a quick question.
Mr. Rea has a question
Sure.
for you.
Thank you. I want to just zero in on the fact that you mentioned if a fetus is born alive, then it's alive. But isn't not true that under the provisions that we're going to be dealing with, currently there needs to be 2 doctors present during an abortion, specifically for the purpose, one to tend to the mother and the second to tend to potentially a live birth of the fetus. But now we're eliminating the 2 doctors and just having one, correct?
Yes.
Thank you.
You may continue, Mr.
Continue to
Lawler.
yield for my questions?
I'm sorry?
Will you continue to yield?
Yes.
Thank you. Does this bill expand Roe versus Wade?
No.
Does Roe versus Wade require states to allow non-physicians to perform abortions?
Well, not everything in Roe v. Wade deals with all aspects of New York state law. New York state licenses medical professionals, and it is the state law that controls whether or not what medical professions are licensed. And since in the last 50 years, a great many things have changed in healthcare, as many of us have experienced. And so in the 50 years, New York State has added several other licensed professionals who deal with reproductive health services. They include a physician assistant who operates with the same practice scope as a physician, but operates under the supervision of a physician, a nurse practitioner, and a licensed midwife. Now, we've been clear at the beginning of my explanation of what the bill does, that the physician and physician assistant can do surgical abortions, whereas the licensed nurse practitioner and the licensed midwife can do a medical abortion and do the follow-up care necessary.
Thank you. Does your bill contain any conscience protections if a doctor or a hospital doesn't want to engage in these practices? Is there anything to protect their conscience? Is there anything to protect them from losing their license or losing funding?
Well, we don't do that in this bill because there's already an existing law that protects the hospitals in that regard, and physicians individually.
Is there any provision in this bill that will allow for, fund, or require counseling for women who've had abortions and they regret it and they seek counseling or need counseling?
No. It's my understanding from extensive reading by of the surveys done by the Guttmacher Institute that it is overwhelmingly women are pleased that they had the choice to decide when to become a parent or not.
Are you saying it's 100%, that no one regrets it?
I didn't say that.
So is there any funding or any
Mr.
support for those who do?
Mr. Lawler, your time is up if you so choose.